in like the sweepstakes and contest space. So if anyone does have interest in that area, please let Connie or myself know, and that might be something that we can talk about in a future meeting as well. So we're just going to jump right in because we have a lot to get through. Honestly, a lot of these things could probably be their own 1 hour sessions. So everything's going to be kind of high level, but today we're going to be talking about sort of trademark basics for entrepreneurs and small businesses. This is something that I am super passionate about. I've been working with Cortex clients in the Cortex district for about 4 years now. And it's something that I think is really valuable for young business owners to know so that you can make informed business decisions as you're getting your ideas off the ground. So just a brief outline of what we're going to talk about. We're going to start with just defining what a trademark is, how you go about picking a strong trademark, using your trademarks appropriately, the registration process, why you should do a trademark clearance search before you do anything else. And then we'll end with a whirlwind discussion of trademark infringement and enforcement strategies if we have time. So one question that I get asked very often is, what's the difference between a trademark and a service mark? The answer is that they're technically the same thing. A trademark is a word, name, symbol, slogan, logo, something like that, used to identify goods and distinguish them from those sold by others. A service mark is a trademark that is for services. That's really the only difference. So it really depends on whether you are applying your mark to a physical good or product, or if you're applying it to a service that you're performing for others. So examples of trademarks, you see them in the world all day, every day. You just might not know that they're called trademarks. So the Coca-Cola symbol in that distinctive red color, the Apple logo, the Toyota symbol, the Nike swoosh, even though it doesn't have the word Nike on it, that functions as a trademark when applied to footwear. And service marks are, again, pretty much the same thing. So they're just applied to services. FedEx is a really good example. You do see them on the trucks, but they don't sell trucks. They're selling delivery services. So that's sort of the distinction there. And my favorite time of the year is Girl Scout cookie season. So I always like to throw the Girl Scout logo on there because I see that mark a lot this time of year. Sorry, my computer is locking up as I'm trying to change slides. So 1 second. I think my PowerPoint might have crashed, so apologies.
We've all been there.
Okay, here we go. So what does a trademark do? A trademark basically serves 3 specific functions. So the first, like I said, is to indicate the source of a good or service and distinguishes that good or service from competitors. So when you're out in the mall and you say, oh, those are Lucky Brand jeans, you're saying that because you know that those jeans originated from the Lucky Jean Company. The other function is that it guarantees the quality of the goods or services that are bearing that trademark. So we all expect goods that come from a specific place to have a certain level of quality to them, or to not have a certain level of quality if we've had a bad experience with that brand in the past. So for instance, I would say, oh, I've heard that Lucky Brand jeans last forever. I've had a very good experience with them. Finally, trademarks create and maintain demand for the product or service through advertising. So you know that only the owner of Lucky Brand jeans is going to be able to use their trademarks in advertisement. If a third party is using those marks, they're using it improperly, and that's where we get into infringement territory. But at a basic level, it's just a way to identify that your goods or services are yours and not coming from a competitor. So for that reason, it's really important to choose a strong trademark because that's how consumers are going to recognize you and your brand in the marketplace. So choosing a strong trademark offers more protection because it better distinguishes you from others in the marketplace. Strong trademarks are easier to register, they're easier to protect, they're easier to keep other people from using them, and you're less likely to receive demand letters or other infringement claims if you have a strong trademark, which at the end of the day is going to save you time and money as a business owner. So to determine whether a mark is a strong mark versus a weaker mark, we have to look at what trademark lawyers lovingly call the spectrum of distinctiveness. So there's different categories that marks can fall in from a strength perspective, and each category has its own rules when it comes to whether something is protectable or not. So at the low end of distinctiveness is generic marks. And generic marks refer to it's basically just a common term for a genus of goods or services. They are never ever protectable at a registration level or even just using them in the marketplace. No one can claim a monopoly over spring water, for example. Spring water is spring water. It's a word that you have to be able to use to describe the product. It's generic. You can't protect the words spring water as referring to water. I list aspirin here as an example because aspirin actually used to be a registered trademark, and through time, it became generic through misuse. So it's a word called genericide, which we're going to talk about in just a little bit because it's one of my favorite words. But it just goes to show how using your trademark appropriately is very, very important from a business perspective because trademark rights attach through use. So it's use it or lose it. If you're not using the mark anymore on your goods and services, you don't have protection anymore. Or if you're using it improperly, you can lose that protection despite doing the things that you think that you're supposed to do. The next step up from generic marks are descriptive marks and suggestive marks. So descriptive marks are terms that describe a characteristic, feature, function, sorry about that, or nature of the product or service. Generally, descriptive marks are not protectable unless you can show evidence that they have acquired secondary meaning. Typically, that comes through longstanding use of the mark. The statute says 5 years of continuous use before you can claim acquired distinctiveness, or if you can prove substantial marketing or sales, things like that, that show that the public has begun to associate your mark with your goods or service despite the fact that it's a descriptive name. So an example of descriptive marks, American Airlines, they're an airline company and they operate in America. So arguably that is descriptive, but obviously though they've used the mark for a very long time, they've acquired some very strong brand protection in the mark American Airlines. Slightly above descriptive marks are suggestive marks. So suggestive marks are terms that require imagination to associate the mark with the product. Suggestive marks, it's kind of a feel thing, but typically these marks are inherently distinctive. You can register them. They may have a limited scope of protection depending on what the mark is, what you're applying it to. But some examples of suggestive marks are like chicken of the sea for tuna. It's suggestive of fish, but it's not it doesn't immediately call to mind, except for the fact that it's a trademark. It doesn't immediately call to mind tuna. It takes a step of imagination to go from point A to point B. So suggestive marks are typically where a lot of companies are operating in the trademark space. It's very difficult to come up with like a brand new word or a brand new term. So it's not to say that you should never use descriptive or suggestive words in your trademarks. You just need to go into that with your eyes open, that you either may need to use it for a while before you can register it, or that you're going to need to acquire some of those additional things in order to be able to actually protect it with the trademark office. The best marks and where you really want to be are arbitrary marks or fanciful marks. So arbitrary marks are known words that have no association or relation to the claimed goods or services. And again, arbitrary marks are immediately registerable with the trademark office. So a great example of arbitrary mark is Apple. Apple computers. We all know what an apple is in terms of the fruit, but the fruit has absolutely nothing to do with computers. And that's why Apple has been able to acquire such strong brand protection in connection with their computers and their services. Same with Domino's for pizza. Domino is an actual thing, but it has absolutely nothing to do with pizza. So the application of that word to, you know, the pizza context is novel and completely protectable. And finally, the cream of the crop is fanciful marks, which are newly created terms that have no meaning except for in the context of the trademark. So Google, Xerox, Kodak, those are not actual words in our normal parlance, aside from the fact that they refer to those companies and those services. They were created to refer to those goods and services. There are some special trademark rules when it comes to some specific material. Names can be difficult. So surnames, names of living individuals, and names of deceased individuals can be difficult to protect. And there's some very special rules that apply to them. Geographical indicators are also typically not protectable, mostly because it's either completely descriptive or if you're trying to be cute, it could be considered like a misdescriptive argument. So that can be an issue sometimes. Any representations of flags, whether that be on the city, state, or the federal level, are not protectable. So if your logo has the American flag in it, or something that looks like the American flag, if it has the flag of Missouri or the flag of the state of the city of St. Louis in it, you're going to have a hard time protecting that. There's actually statutes in place that prevent you from protecting that. Foreign words are protectable, but you need to consider the English translation of those words. And if the English translation is descriptive, then the foreign word is also going to be considered descriptive. Disparaging and scandalous marks, I put an asterisk next to that because that has actually changed in the last couple of years. It used to be that you could not protect disparaging or scandalous marks, so anything with a swear word in it was immediately out. But there was a Supreme Court case a couple of years ago that basically got rid of that restriction. So now if you want the F word in your mark, go for it. You're going to get it through probably, as long as it doesn't have any other issues. So, you know, that's a business decision of whether that's the branding you want to put out there or not, but it's available to you. And finally, ornamental marks. So these refer to marks that most typically are put on clothing. Something that kind of like what I'm wearing, this Husch Blackwell in this placement, sort of like the breast pocket area, that is typically considered to be trademark use in relation to clothing. However, just putting a design on like the front of a t-shirt really big is not protectable trademark use. That's what's considered ornamental use and an ornamental mark. And you're not going to get that through the trademark office. Clothing in particular, like I said, is the main one. But we've seen an increasing number of these rejections for a lot of just merchandise in general. So if you're selling coffee mugs, if you're selling keychains, anything of that nature that have like your logo on them just as a design, it's probably not going to be considered use of that mark on those items. It would really need to be like on a tag affixed to it or in some other way that indicates the source and not just that you put a fun design on the front of your merchandise. Using your trademark properly. So you always want to use your mark as an adjective and not as a noun. So for instance, and we all do it, I'll have a Coca-Cola soft drink. Not just I'll have a Coca-Cola. This is where you start treading into genericide territory. But again, like I said, we all do it. What do you have? Well, I'll have a Coke. You know, it's natural for us to do that. And that's why as business owners, it's really important that as you start developing your materials, that you're using your marks in a way that's going to best protect them. And in that line, using a generic term following the mark is always a good idea. So instead of saying a Coca-Cola, saying a Coca-Cola soft drink. Soft drink is the actual product that you're putting it on. Coca-Cola is the mark that you're protecting. You also want to avoid using the mark in plural form because that just reinforces the idea that you're using it as a noun. So instead of saying enjoy drinking Coca-Colas, you would say enjoy the taste of Coca-Cola soft drinks. You also want to avoid using the mark as a verb for services in particular. So Xerox this please, or, again, we've all done it, but that's the reason why Xerox used to be a trademark and now it's not. We consider that to just be a synonym for copying something on a copy machine. You also want to use the mark consistently. So this is particularly important for design marks and logos. So if you have a particular color, if your logo is laid out in a particular format, capitalization, things like that, all of that matters for trademark protection. And the more different ways that you use your marks in your materials, the weaker your mark is going to be, because it's not a consistent unified front for the public to see, that this is all from one source. So the more consistently you can use your marks, the better off you're going to be. And like I was just talking about, don't use the mark in an ornamental fashion. So particularly for goods and clothing in particular, other merchandise, if you're going to use your mark on those products, use them on a tag that's either affixed, or like on clothing, the tag inside the nape of the neck is the best place to use it. But just something that's affixed to it, like a hang tag, that's what's going to give you your trademark use, and not just putting it on the front of your shirt. So genericide and descripticide is really the reason why we have these use rules, because you really want to avoid this as a business owner. So there's this great quote that says, "The path to marketing oblivion is littered with the good intentions of zealous advertisers and marketers who made their brands household words and then dictionary terms." And that's the end of your trademark use. So aspirin, thermos, yo-yo, all of those things used to be protected trademarks. And through use over time, they became so well known and so widespread that they no longer identified a source. A yo-yo now is just a yo-yo. So the mark here would actually be Dunkin'. Or Imperial. That would be the mark there, and not yo-yo anymore. It's a generic term. And this is something that still goes on today. Google actually just a couple of years ago had a huge decision and victory in court, where somebody tried to say that Google is no longer a trademark. It's a generic term that just refers to searching something on the internet. Because how often do we say, "I'm going to Google that," or "Hey, can you Google this and tell me what you find?" Google actually won, because they said that even though people do use that term sort of generically, they always refer to using the Google search engine. You don't say "Google this" and go to Bing. If you do, I would like to talk to you, because I have some questions. Typically it's the most prevalent search engine in the world is Google. And that was really how they overcame that decision. It was kind of a shocking decision for a lot of people in the trademark industry. So just another example that even if you get really big, you're not immune to these kinds of issues. Velcro, if you ever have some spare time, the Velcro legal department put together a YouTube video, like a music video, about protecting the word Velcro, and how Velcro is not a generic term. The generic term is a hook and loop strip, because we all just refer to Velcro as Velcro, but it's actually a brand name. So if you ever have some spare time and you want to look up that video, I highly recommend it. It's very entertaining. Even to non-trademark lawyers, I think you'll get a kick out of it. So intellectual property and social media. This is another question that I get a lot from young business owners. I recommend making social media an important part of your business startup sort of as you go, because you want to make sure, one, that you are securing your social media names ahead of time. It's very difficult to nab them if it's already been taken. And using your intellectual property on social media, the same rules still apply, even though social media is typically kind of an informal platform that a lot of business owners use. So make sure that your marks are being used properly in your social media posts and your advertisements that are going out on social media. Think before you post. It's difficult to sort of pull a lot of those things back once they've been put out there on the internet. If there are any images, music, videos, anything like that that you're using in the post, you want to make sure that you have the rights to whatever that material is, because copyright is a thing that's sort of outside the scope of this presentation, but it's important to make sure that you're not using something that you don't own. You could get into a lot of trouble, and it could cost you a lot of money. Use of materials from sharing sites like Pinterest. It might be fair use for the individual, but if you're a business and you're using it in a commercial way, that could still land you in some hot water. So just be mindful about using anything that you find on the internet. And also check the terms of use from any online source that you want to use for text, images, videos, etc. Even if it's from a free like stock photo or a clip art site. Because sometimes they'll say that you can use it for personal use, but not for commercial use. If you're using it for your business, you want to make sure that you're complying with those terms of service so that you don't get a nasty gram down the road saying that you're using it improperly. So how do you make sure that the mark you want is available? So I always recommend a clearance search for pretty much any mark that you're wanting to use commercially. If you don't perform an adequate search and that were to come out, if you were to be challenged, that can result in potential liability for you. So there are a couple of search options. The best option, and I'm not just saying this because I'm an attorney, but is really to call a trademark attorney. The reason being, we have access to databases and tools that make searching a lot easier, and we can just do it a lot quicker and more efficiently. We know what we're looking for. We know what's going to be high risk versus low risk, and we can really give you a great just sort of snapshot of what's out there, what that means for you. Or if there is something out there that's problematic, we can try to come up with a strategy for you of sort of how to go about potentially protecting that mark in a slightly altered way. But attorneys can be expensive, totally get it. Your second best option is going to be to use the USPTO's website and Google at a bare minimum. So you can actually search trademarks on the USPTO website yourself. The one caveat with it, that search engine, it's very finicky, so it's going to search exactly what you type in the box. It's not going to search permutations of that mark. It's not going to search misspellings. It's not going to search design versions that might include that word can be difficult to catch as well. So you want to run kind of a broad search strategy if that's what you're using, and run a couple of different queries just to make sure that you're capturing everything. And Google is a really powerful tool. Being able to go online and see who, even if they don't have a trademark registration, who's using the mark, even if they're not in your immediate area. If there's only one person that's using it, you know that that's a potential problem. If you're finding a lot of people that are using the mark, it's a slightly different problem, but you're probably not going to get a demand letter from somebody if there's a whole lot of people that are using that mark. So at a bare minimum, I recommend doing some good online searching using the public tools that are available to you. So what if you find somebody that might be using your mark? You can do a trademark investigation. These investigations can determine just one, whether the mark is actually in use, who's using the mark, how long have they been using it, and how is it being used on what goods and services? Is that related to what you are doing or what you want to do? All of those things are really important questions. That's one area where the internet can be a little bit difficult sometimes, because you might find a website that looks super old, hasn't been updated in 10 years. And there's a question about whether these people are still around or not, because if they're not around, then they're not really a problem. But if they are still using, then that's important to know. Again, we have investigators as attorneys that we hire all the time to do these kinds of things. The investigations are not super expensive. I think our local option is like $300 for them to do the investigation and everything. So it's always an option for you if you run your search and you're just not sure what the risk level is. An investigation might be a good tool for you. So once you've satisfied yourself that your mark is available, the next obvious step would be registration. Keep in mind that registration is not required. So you can use the mark and never register it with the Federal Trademark Office, and there's absolutely nothing wrong with that. You still acquire rights in the mark that are a little more limited, but you do have them. You would have enforcement options if you were to come across somebody that was trying to use the mark after you had started using it. There's a big question about first to use versus first to file. That is honestly like a bar exam question level of analysis that is, again, could be a whole separate presentation. But basically, if you are the first to use, you do start acquiring rights in the mark regardless of whether you've registered it or not. I do recommend filing as soon as possible if registration is something that you are wanting to do, because being on record, so somebody, even if they start after you and you're not registered, they could still file an application with the Trademark Office and it might get through. You would have rights to challenge it, but you would have to be, one, aware that that person has filed, and then put the things in motion to stop that application from going through. So it does put more of the onus on you. If you file early and you get your registration, the Trademark Office does a lot of that work for you, to be honest. So if somebody were to file after you had filed your application, even if it hasn't registered, the Trademark Office is going to cite your application against the later party. So there are some real benefits to filing and getting a registration through the Trademark Office. When you should register, you can actually register before you even start using the mark. So we call that an intent to use application. For intent to use applications, you basically just file like you normally would. You say, this is the mark I want to use on these goods and services. The mark goes through the review process with the Trademark Office, but stops short of registration. So you won't actually get your registration until you start using it and provide that use to the Trademark Office. If you are already using the mark, that is also perfectly fine. It's going to save you an additional filing fee if you're already using it. So in that case, you would just provide all of the information up front to the Trademark Office. Hopefully it'll sail through, and then you'll get your registration certificate in about a year. Particularly with the pandemic, it's not a quick process. But just because you aren't using it yet doesn't mean you can't go ahead and get on file. And again, I always recommend getting on file as soon as possible once you decide that you want to register. And the last question I get all the time is, do I need an attorney? The answer is no. I mean, you can file the trademark application with the Trademark Office yourself, but it's always a good idea to work with somebody that understands and has been through the process. And a trademark attorney like myself, I mean, I'm probably on hundreds and hundreds of trademarks with the Trademark Office. So I have a really good understanding of the process, what to expect. And that would be the benefit of using an attorney over doing it yourself. So federal registration provides many advantages. The first is nationwide rights. So I keep saying that rights attach to your use, and that's absolutely true, but the rights only apply to those geographic areas where you are using the mark. The internet has made this a little murkier, but traditionally, if I were to start using the mark in, the Missouri and Illinois area, and somebody in Florida started using a mark very similar to mine, but there's no overlap geographically, I would have a very difficult time challenging that mark in Florida. If I have a federal registration, it doesn't matter if I've never made a sale in Florida. I can still challenge them based on the fact that I was the first one to use it and I was the first one to register with the Trademark Office. So it can give you a wider footprint in terms of enforcement. It also gives you presumptive nationwide priority, which again is the assumption that you were the first one to use it. That's just something that is a given. You don't have to fight about it. If you get into an infringement battle, you're presumed to have been the first one to use it. It also gives you this, what's called a presumption of validity, which is just saying that, yes, it's a valid trademark. And again, we don't have to fight over it. It's just something that you can skip if you were to get in trouble. Incontestability after 5 years of registration, if you use it properly, can be huge because that actually limits the ways that people can challenge your trademark. So they basically have to say that you aren't using it anymore to get a registry, to get your mark canceled or to challenge your mark. They can't say anymore, well, I used it first or something like that. It's just not available anymore. So registering early so you can start that 5-year clock can also be huge, particularly if you know that there are competitors using something similar or something like that. And finally, if you are interested, you can actually file a trademark registration with the US Customs Office. So if you're importing or exporting goods as part of your business, that can be a huge stopgap measure for enforcement, because customs, again, will do a lot of the work for you, and they'll actually stop infringing products at the border before they even get into the country. So depending on your business and what it is that you're doing, that can also be a huge benefit of registration. The registration process is actually fairly simple, though not quick. It's all online, so it's all done through the uspto.gov website. The filing fee is based on the number of classes that you claim in the application. So every good and service is categorized into one of, I believe, 42 or 43 classes of goods and services. So if I'm filing for example, clothing items and coffee mugs and keychains, that's actually 3 classes, even though it's all considered sort of generic merch from a business perspective. So if I wanted to claim all 3 of those things in the application, we're looking at 350 times 3. So $1,050 in filing fees for 3 classes. In terms of timeline, I wish I could still say it was 6 months to a year. Unfortunately, with the pandemic, the trademark office is incredibly backlogged. So it's probably going to be 6 months before you even hear anything from the trademark office. If you have any back and forth with them, you're probably looking at 1 year to 18 months at this point to get a trademark registration in hand. So it's not quick, but like I said, you don't have to register to use it. So I usually tell clients not to let the registration process sort of uproot what they're doing from a business perspective. From your perspective, it should be business as usual. Start implementing use of the mark on your timetable, and then we can work through the registration process as it comes up. But I would never let that determine when you begin using the mark. The general process is once you file the application, it's assigned to an actual person called an examining attorney. They are actually attorneys. So each application is reviewed by a person, and then they will send an email. Sometimes they'll call if it's a really simple issue, but basically they'll send you something that says, okay, we've received your application. These are the issues that I see. Those issues can range from something as simple as, we don't like the way you worded your goods description, and here's how we would recommend that you do it. That's a very simple one. Or they can be more substantive and say, hey, we found these other marks that we think are too close to yours, so we're going to refuse your application. But you have the opportunity to make arguments as to why you don't think there's a risk. Once you satisfy that back and forth with the trademark office, which can take a while depending on the issues that are raised, the mark is then published for a period of 30 days in what's called the Trademark Gazette. Once I say 30 days, it's not like after 30 days, they immediately take it down. Everything is a process. So sometimes it's up for longer than that. But once your publication period closes, that tells the trademark office that nobody has opposed your registration. So the whole purpose of publication is to give business owners the opportunity to step forward and say, even though the trademark office doesn't think there's a problem, I do, based on my rights in this mark. It's very unlikely to happen. It does, certainly. I'm dealing with a few of them right now, but once that publication period closes, the opportunity to challenge the mark, it's still there, but it's more difficult for people to do that, and it costs more money. Once that mark has published and that's gone through, you'll either get what's called a notice of allowance if it's an intent to use application, or a notice of acceptance. If it's a use-based application and that just says you've met all the criteria, your application is good to go. Once if you've already used the mark, great, you'll get your registration certificate. If it's an intent to use registration, then once you provide that use information that I talked about earlier, you'll get your registration certificate in the mail. Again, it can be months from the time they say, yep, everything is great, to when you actually get your registration certificate. So even that process is not quick. It used to be a couple of weeks. We're looking at months now. But again, just know that the registration process is voluntary and should not affect your business timeline at all. So another main question that I get a lot is with regard to the registration symbol. So you should only use the circle R if you have a registered trademark with the federal government, so the United States Patent and Trademark Office. If you are using the mark on an unregistered basis, or if you have decided to register through the state, which is sort of outside the scope of this discussion, that's when you use the superscript TM or the SM symbol, TM for trademark, SM for service mark, depending on what it is that you're doing. You can still use TM on a service. It's not wrong. It just depends on what it is that you want to do. But that's the difference. It's a federal registration versus if you're unregistered or relying on a state registration.
Got it.
So I wanted to leave a little bit of time for questions and discussion. So if you guys have questions, we can certainly stop here and do that. And if there aren't any questions, I can go into the last couple of slides on infringement and that stuff. But does anyone have any questions so far?
What's a common fee to engage services to have a service trademarked?
So you can certainly there are trademarking services out there. I know LegalZoom has them. I can't remember the name of it. The problem with services like that versus engaging an actual attorney is they often will just sort of take your money, file exactly what you give them, and they're not really going to analyze it for you, and they're not going to tell you, hey, this is a bad idea if it is.
Sure.
I've certainly had those uncomfortable conversations with clients because people get so attached to their trademarks. They come up with these logos and these names and they get so attached to them, and then I have to come back and say, I'm so sorry, that has like a 0% chance of happening. And my goal is always just to try to save my clients as much money as I can. I don't want you to pay that filing fee if it's just not going to go through. So typically for my clients, I usually tell them for a search ahead of time, you're probably looking at $900 to $1,200 to run the search and provide an opinion. And then to actually prepare and file an application, you're probably looking at $700 in legal fees, plus the filing fees would be charged separately. That's only through filing. So it's very difficult once you file the application to upfront give a cost estimate, because if we file without a search, for example, and a ton of marks come back cited against us where we have to make some pretty substantive arguments, that's obviously going to take a lot of attorney time and it's going to cost money. But that's the other thing about engaging attorneys. You can always ask for a cost estimate ahead of time. So when they get the office action in and they send it to you and say, okay, this is what we got from the trademark office, and these are the issues that would raise. I always recommend asking what a ballpark estimate is going to be for preparing a response. Some issues are as quick as a phone call to the examiner. So, 20 minutes of my time, you're looking at probably $300. If it's a substantive issue where we have to do research and we have to prepare arguments, you're probably looking at $3,000 to $4,000. But at that point, I can tell you, okay, based on the issues that were raised and what I know I'm going to have to do, here's a cost estimate.
Okay, perfect. Thank you.
Yeah.
Tara, we got a question. ML. Tara, can you talk a little bit about after you're registered, what you need to do kind of like on an annual basis to manage and maintain?
Yeah, absolutely. So once you get your registration certificate in hand, your next maintenance filing is going to be between the 5th and 6th year anniversary of your registration date. So by the end of the 6-year anniversary, you need to file, it's called a Section 8 and 15 declaration. That basically just confirms, yes, I am still using the mark, and here's examples of how I'm using it. There is a filing fee associated. I apologize, I don't remember the filing fee offhand, but it's usually a couple $100s per class. After that maintenance filing, your next one is due at the 10-year anniversary of your registration date. And it's the exact same thing. Yes, I'm still using it. Here are examples of how I'm using it. After that, it's every 10 years.
Is there anything that you should be doing defensively, like on an annual basis after you're filed, to go out and search and make sure that your mark isn't being infringed? Is that not you, or?
Yeah, so it kind of depends on what your budget is and sort of what your worries are. So there are certainly third-party services that we work with, but they're called watch services. And basically on like a monthly or a weekly basis, I get reports from these companies for the marks that have engaged that service, that search applications that are being filed or applications that are being published, depending on how you set up the watch service. Typically, they're not super expensive. You're probably looking at a couple $100s a year if you just want a really basic watch service. The other thing that you can do is set up a Google alert, just so you know you can get news articles of people that might be using your trademark. That's sort of one free way that you can sort of use the tools that are available to you. But a lot of it, if you're not using a watch service, is you can just rely on the trademark office to do their job. And they do a pretty good job of stopping things. I've only had a couple that have gotten through to a watch where I thought, how on earth did that get through? That's obviously a problem. The trademark office does a pretty good job on its own. Or you can do your own periodic searching. If you become aware of somebody that's using it, obviously you want to reach out to an attorney right away so that they can look at it and analyze it for you and give you sort of an opinion of, yes, this one is worth fighting, or, no, it's not worth fighting. But I would say the biggest thing would be just to keep your eyes open in your industry. You guys as clients know your industry better than I do. So, you're going to become aware of somebody else that's using your mark much faster than I would be, unless we have a watch service.
I have one more question, Tara, real quick.
Yeah.
So say for instance, you had a trademark and then say your business closed down, or you're not in business anymore. Is there any like action that you need to take for that, or you just let it run out?
Yeah, so typically in that scenario, I would say don't do anything. It'll take care of itself at your next maintenance deadline when you don't file. So usually what happens, you miss your deadline, it'll stay live on the Trademark Office website. I would like to say for a small period of time, but honestly, it could probably be years. It just depends on how quickly they decide to update their listings. But in theory, within a year after you miss your deadline, it should be removed off the trademark register. But if you see it's still active, if you decide to go and look one day and you're like, wow, this deadline was 2 years ago and it's still showing as live, there's nothing you need to do. It will eventually correct itself without you spending any time or money on it.
Right. Okay. Good to know.
Any other questions? Okay, well, let me just fly through these infringement slides, and if that triggers any other questions, just feel free to stop me. So trademark infringement results when somebody uses your mark without your authorization in a way that is likely to confuse consumers. So when there is infringement, it can result in injunctions, which is basically a court saying, no, you can't do that activity anymore and putting a stop to it. It can result in monetary damages, attorney's fees. So it can certainly add up very quickly. And there are many factors that are considered when reviewing whether activity, constitutes infringement. Depending on what district you're in, judicial district, there could be as many as 13 factors that courts look to determine whether something is infringing or not. So it's not an easy question. Usually if I get an email from a client that says, hey, is this a problem? I can say, no, you do realize like this is not an easy question for me to answer. I'm going to have to do some work and it's going to cost some money. But it is something to be aware of. I get a lot of questions about use of a mark as a social media handle, which is part of the reason why I recommend considering social media accounts when deciding on your brand name and securing them absolutely as soon as possible. Because if you later find out that somebody else is using your social media handle, usually my answer is, wow, that sucks. Because there's not much that I can do in that realm, unless you can show that the use is by a competitor and being done in a way to confuse people. You're going to have a really hard time securing that account. And this goes for large brands. I have a client that it's a huge national food company. And one of their brands, they did not have the Instagram handle to for some reason. And just a private citizen was using it for her own Instagram handle. And the client wanted us to try to get it. And I said, unless you can offer her some money and have her transfer it to you voluntarily, there's just unfortunately nothing I can do because she's not doing anything wrong. She's not using it in a way, she's not posting anything about your product. She's not posting about competitor products. It's literally just like a 26-year-old girl in the middle of nowhere that's just using this as her Instagram handle. So I think it's really important, given how prevalent social media is in today's marketing strategy and business, it is, I would say, critical to consider that. And if you are searching your mark and it's available, I would also recommend searching the major social media sites as well, and just making sure that, if that handle is particularly important to you and it's taken, and that's a big deal to you, you might want to choose a different mark that you can get those rights to, depending on how important that is. But just using it, I guess the point of that is just using it as a social media handle is an infringement. So somebody saying, hey, they're using it, that doesn't arise the amount of infringement. They have to be doing something else intentionally confusing. There are a couple of tools, what I call the toolbox, that a lot of businesses can use from an enforcement standpoint. The first is Google Business Verification. So this came up, I was like a brand new attorney, and a situation came up where a client, when you typed in their business name into Google, you know how it pops up with the little map and the name of the business and the address and the website and all that stuff in that little box on the right. When people typed in their business name, the box that was popping up wasn't them. It was unclear who had tied that information to that particular business, but it was just incorrect. You can actually, through Google, and I believe it's a completely free service, at least it was the last time I looked at it, you can do a business verification to verify that when people Google your business and that information pops up that it's you. They have a whole system for doing that. And so I recommend doing that right away, just to, again, make sure that you're securing all of that from the very beginning. We managed to get it fixed, but it did take some doing on our part. We had to file a couple takedowns with Google, and we had to bill for all of that. So the more you can do a lot of this ahead of time, the less you're going to have to pay somebody like me to fix it for you down the road. The other thing that you can do is the Amazon brand registry, which, here it is. I have a slide. So it's called Google My Business. And this is really what it looked like. So you say start now, and then you can type in your information for your business and secure all of that. So the Amazon brand registry, if you're selling product through Amazon, or you are aware of other people selling your product through Amazon, which happens all the time, you can actually register your brand with the Amazon brand registry, and it gives you some additional enforcement and takedown tools against third parties that are selling your product. The one caveat is that, at least last time I looked, you do need to have a federal trademark registration to register with the Amazon brand registry. But if you have that, then you can tell them what the mark is. You can provide them with an image of your logo, images of products that are bearing your mark on them. And Amazon will send you reports of activity on Amazon that uses those marks that is not you. So that can be a really powerful way for you to sort of monitor how your mark is being used on Amazon, because it's becoming a huge problem with third parties selling infringing products on Amazon and just acting like they're the brand owner. It's very difficult. So again, so the brand registry actually gives you some proprietary searching as well, and some additional reporting tools, so you can more easily take those products down off of Amazon if you're finding them to be a problem. So each social media platform has its own internal policies and reporting mechanisms for infringement. So if you are finding your brand or your products being used by competitors on their social media platforms or something like that, you can actually report that through the platform. And it's really through the platform though. So each one has its kind of own reporting that you have to go through, and each sort of asks for different information. But most of them are going to ask who you are, ask for verification that you own the mark, which again, usually they want a registration certificate. I have certainly been hired a couple of times to argue with Facebook and Twitter about, you know, the fact that we don't have a registration certificate, but that like our client still has rights. But having a registration certificate that you can provide is going to make that a lot easier. And again, a lot of the platform's mentality on this is that it's your job to monitor the use of your marks. So I don't think many of them have a lot in terms of like searching. But if you become aware of something on one of these platforms, every single one of them has a way to report that. And you can find that usually in the terms of service. They often have an entire section dedicated to intellectual property. And often it's just a click through fillable form that you fill out. So it's pretty user friendly once you find it. But if you ever have an issue with that on a platform, go through the platform. And just keep in mind with social media, like there is no one size fits all strategy. You want to make sure that your business has a social media policy in place. If social media is going to be an important part of your marketing strategy, you want your marketing people to know what is and is not important, or is not acceptable in social media. And a lot of that, again, comes back to using the mark properly. So a lot of my job tends to be educating marketing departments and marketing individuals about, using the registration symbol, making sure that, they're using the mark exactly as it's registered so that it's consistent, those kinds of things. You want to make sure your employees are trained on all of that as you sort of build your teams out. So at the beginning, it might just be you and you've come to this presentation. So now you know everything that you need to really know. But as you add and bring people on, you might need to train them or get them in touch with people to make sure that they're doing what they need to do. And again, just think before you post. It's very, very difficult to take anything back once it's out on the internet. I spend a lot of time sort of counseling clients on making sure that, if you have somebody handling your social media, they have a good head on their shoulders. They are aware of the company's vision, how you're wanting to position yourself in the marketplace, and they're not posting things that are inappropriate, using your brand names, or anything like that, because it can get haywire very quickly. And just once it's out there, it's very difficult to claw that back on the internet. So the last thing that I'll just end on, cease and desist letters. So if you become aware of somebody that's using your mark, I like to call them nasty grams, but you can always send a cease and desist letter, hire an attorney to send a cease and desist letter on your behalf. They don't always have to be contentious. I always like to end with a slide of a Netflix letter that went out to a pop-up bar that was using, it was called the Upside Down, and it was obviously affiliated with Stranger Things, right when Stranger Things was super popular. And this letter is just fantastic. It's such a good example of how you can use legal action like a cease and desist letter as part of your marketing strategy. It doesn't have to be contentious. You can have fun with it. And I did not send this letter, just to be clear. But it sort of made the rounds on the internet back in 2017, and it's absolutely phenomenal. So I hope you guys enjoy it. I can stick around for another couple of minutes. I know we're a little over time, but if anyone has any last questions or anything like that, please chime in. I'd be happy to answer before we all jump off.
Thanks so much.
Great.
Thanks for joining us, guys. And I did put in our chat too, we're gonna have at 5:30 here, another speaker. So you can join us virtually if you'd like. We started our founders series. We're gonna have an entrepreneur, ITEN mentor, speak on his entrepreneurial journey. So like I said, I just threw that up in the chat. So if you're interested, please join us at 5:30. And Tara, thanks so much for a very informative, great session. We really appreciate you taking the time and teaching us some really good things to know. So we appreciate it.
It is my pleasure. Please let me know if anybody has any questions after the program. Feel free to circulate my contact information. I'm more than happy to answer anything.
Right. And I'll be happy also to share Tara's slides. She did say that we could share the slides. So I will follow up with you, and we'll have also the video as well. So we'll follow up and get you that information as well. Thanks for joining.
Thank you.
Thank you. Have a great day, everyone.
Okay, bye-bye.